A very good morning to all of you. Good to see all of you. And first of all, may I wish all the advocates who are going to take the test the very best, that I hope they will do well. In fact, the Constitution charges all of us to strive to attain excellence. It's a fundamental duty, as you know. Whichever walk of life, whatever point of time, wherever you are, whatever you are, it's a bounden duty of every citizen to strive to attain excellence. Because you can't always blame government, authorities for whatever is going wrong. We have to look deep within ourselves that a good part of the blame will actually lie at our doorstep. Because we are not doing what we should be doing, the system fails. So I just want to make this prefatory remarks because we are under a constitution and we have duties as much as we have rights, and therefore we must hearken to the duties as well. I've been charged with the duty of talking to you about 5 cases I've selected. I remember when I came for the first time here in the year 2018 or 19. I must confess, put in a lot more work. I was a little bit, or rather perhaps a lot more humble. Humility means not just professing that you are humble, but it also means that you actually try and make up for your inadequacies by putting in more work. Now that I have kind of progressed in a manner of speaking in terms of seniority, I've started hitting the bench. Now this means that a lot of my time gets taken up. And much as I like to be, talking at greater depth than I would perhaps this time around, I do not know whether I will be able to do justice to my job. Because the time was short, and as you know, we are all engrossed in so much of work. So pardon me if I do not really measure up to your expectations. I will, however, pass on to my duties. The 5 cases which I have been asked to, I prefer to start with the case relating to the appointment of guardians. In the year 1999, the decision reported in 1999 to SCC 208. The question which is posed, or rather questions which were posed before this court was the validity of Section 6A of the Hindu Minority and Guardians Act 1956. As you know, immediately after independence, as far as Hindu law is concerned, we had a string of legislation which sought to bring in reforms in various aspects of Hindu law. They include the Hindu Marriage Act, Hindu Adoption Act, Hindu Guardianship Act, Hindu Succession Act. They're all very important from the point of view in ushering and consolidating, making clear, clarifying the law. As far as the Hindu Guardian and Wards Act is concerned, 1956, it consists of 13 sections. Before I actually go to the actual decision which was rendered in the said case, I would like to give you a brief conspectus of the scheme of the Act. Section 4 speaks about, you must read it. Section 4 speaks about a definition of the word guardian. Now, guardian is defined in a wide manner because it says includes. It includes what? It includes a natural guardian. It includes a testamentary guardian. It includes a court-appointed guardian. And it includes finally the guardian, the courts of wards. Now you might ask why only these 4 categories, but then it uses the word includes. What are these other kinds of guardians you can think of? Immediately you should note a de facto guardian is also a guardian. straight away you come to section 11 of the Act. Section 11 of the Act proclaims that after the commencement of the Act in 1956, no de facto guardian can alienate the property of the minor, except as is provided in section 8, obviously. Now, section 6 speaks about the natural guardian, which was the subject matter of the case. Now, the law has stipulated as to who are to be the natural guardians of the Hindu minor. We're talking about the minors, obviously. The father is a natural guardian. The section proceeded to thereafter say, after the father, the mother. So the actual question which fell for consideration before the court was, does the mother, who is also a natural guardian in her own right, have to wait till the death of the father to exercise the rights as a natural guardian? Or does the law require a look at with the dynamics and interpretation of statutes? On a literal interpretation, if you have the section with you, it says after the father and after the mother, our father, the mother. So it naturally what strikes us, it's only after the father ceases to exist in flesh and blood that the mother can exist. So during the lifetime of the father, no. The court had before it three petitions challenging the violation of section 6A and also section 19B of the Guardian and Wardship Act of 1890. Now here there is an aside because the 1890 Act, Guardian and Wards Act, as you all know, continues to exist on the statute book. Now what is the role of the Guardian Wardship Act, Wards Act 1890 in the correlation with the Hindu Minority Guardian Act? Section 2 of the 1956 Act proclaims that the provisions of the Minority Act, the Guardianship Act, I will call it the Guardianship Act of 1956, shall be not in derogation but shall supplement the Guardian and Wardship Act, except to the extent that it overwhelms or supersedes the 1890 Act. The 1890 Act will continue to exist side by side. Now, evidence of the same is immediately forthcoming in section 14.3 of the, 8.4 of the Guardianship Act. Why? Because section 8.2 proclaims that if the property of the minor is to be sold, mortgaged, etc., whatever is provided there, restrictions are put on the natural guardian. Now, how does he go about getting the sanction? The provisions of the Guardianship Act is brought in by way of section 8.4 and it proclaims that if a natural guardian wants to get sanction from the court, previous sanction from the court, the provisions of the Guardian Wardship Act will apply. So this is how it coalesces, but both of them continue to exist in harmony together. Now, section 8.1 says that the natural guardian has all the powers to take care of the property in interest of the minor, except the powers which are mentioned in section 8.2, which means sale, etc., for which you have to obtain the sanction. Now, what happens if he does not obtain the sanction? If he does not obtain the sanction, it will be voidable. Please note the word, it is not void, it is voidable. Correct. Now, there is a very interesting aside again, I may indulge in. The property of a Hindu minor can be divided into two categories. It can be the separate property of the Hindu minor. It can also be the interest which he has as a member of a Hindu joint family. Now, does the restriction in section 8.2 apply to the property of a Hindu minor as a member of a Hindu joint family? The answer is provided in both section 6, which defines natural guardian, as also section 12. Kindly read section 12. because as far as the property of a Hindu minor in a Hindu joint family is concerned, it is out of bounds in a manner of speaking of the courts under Section 8. This means that in the case of a Hindu joint member of property of a minor in a Hindu joint family, it is a karta who has power to deal with the property. Now the father may be the karta, may not be. Whoever is the karta in terms of Hindu law, because the joint family itself is a being of which the minor is a part. So in respect of that, nothing in the Guardianship Act will apply. You must always bear in mind. Which is why there is a decision of the Supreme Court, please look it up, which says that if the property of a minor in the Hindu joint family is sold without following the regime under Section 8.2, which means without obtaining the sanction of the court, then Section 8.2 is not attracted. So the separate property of the minor, if it is to be sold, the guardian must apply to the court and get the permission. Now Section 7 deals with the adopted son. In the case of an adopted son, the adoptive father becomes the natural guardian. On the effect of adoption, he becomes the natural guardian. We are talking about a natural son when we talked about natural guardian in Section 6. So it is the adopted father. That is Section 7 and 8 I have already spoken about. Section 9 is very interesting and you should bear in mind because you might get cases to deal with. The question is asked. It deals with the question of testamentary guardian. I have said in the beginning that Section 4 defines guardian as including a testamentary guardian. So there are different kinds of guardian. Just again an aside here, because Order 32 of the Code of Civil Procedure speaks about a guardian ad litem, which means what? Order 32 Root 3 provides that if a suit is filed against a person who is a minor, the court is duty bound to appoint a guardian, because without a guardian, it is as good as the minor not being a party to the suit, which means that the decree which is passed without a guardian being appointed for a minor, it will be a nullity. You can always say it is not binding on him. You have him on the nominee, you have him on the partiary, but you don't have a guardian, a decree is passed against him, then it is treated as a nullity. As to whether it can be treated as an irregularity in certain circumstances when the guardian is there, but no formal order is appointed, there is a lot of case law which I don't want to go into. Coming back to Section 9 of the Guardianship Act, it speaks about testamentary guardian. Now, it is a very interesting, just how the draftsmen in 1950s and 56 in particular were so articulate in simple language they use. You don't have convoluted, long-winded sentences. Section 9, 1 and 2 must be read together. Section 9.1 says that a father of a Hindu minor can execute a will and constitute a person to act as the guardian of the child after his death. Now you may ask, the mother is also a natural guardian. What happens if the father executes a will, makes a person other than the mother of the child the guardian? What will happen to that will? What will happen to that will is explained in Section 9.2. Please read it. Very beautiful, 2 sentences only. 9.2 says that if a will is executed by which a person other than the mother of the child is made the guardian, the will have no effect. Now, will it have no effect for eternity? No. What will happen in a case where the mother will become, this means that the mother will become the natural guardian after the death of the father, when he has left behind a will, making somebody else the natural guardian. But then what will happen if the mother dies in turn without leaving a will That is provided in the second limb of section 9.2, which says that if the mother does not exercise her right, because the mother can also execute a will during her lifetime. So when the father executes a will making a third party a guardian, mother is alive, mother will become the natural guardian. The will be of no use. The third party will not become the natural guardian. During the lifetime of the mother does not execute a will, then the person appointed as guardian by the father, the will revive. Very, very interesting thing. It might, in a particular case, you can perhaps succeed or lose on the basis of, your familiarity with this aspect, which is why I was trying to take you through these provisions. So this is what section 9.1 and 9.2 provide. This is in a case where the father has executed a will, leaving behind somebody else other than the mother as the guardian. Section 9.3 is a standalone provision. It's mutually exclusive. It speaks about a situation where the father does not execute a will during his lifetime. It says a widow or the mother of the children, when the father is disentitled to execute a will, to appoint a guardian. Now you will be surprised, why this widow, mother, what does it mean? And what is the meaning of the father being disentitled? I'll take up the last portion first. In section 6, which defines guardians, the law has made it very clear that to be a natural guardian, even for a father or a mother, he has to remain a Hindu. If a Hindu father converts or a Hindu mother converts, they both lose the right to remain natural guardians. Secondly, the disentitlement arises from the fact that even though he remains a Hindu, he has become an ascetic, a sannyasi. So you should see why is it all being done like this? There is a legislative soul behind it. The soul is that the minor requires care and attention. The guardian is there to take care. So in-law, he is there alive. He is very much a Hindu, but he is not converted. But then he has taken to the mountains. He has become a ascetic and a sannyasi. So then he becomes disentitled. The father becomes disentitled to again perform the functions of a guardian. Therefore, the mother can, under section 9.3, execute a will. Because she has also a right as a natural guardian. It's only postponed till the father, disappears from the scene. The father-in-law becomes non-existent because he has become disentitled, because he has become an ascetic, he has become a sannyasi. He has given up Hinduism, which is a requirement for him to exercise his rights as a natural guardian. So that is the important the distinction between 9.1 and 9.2, which is that where a father leaves a will, 9.3 where the father does not make a will. Now in the case of a widow, where the father has not left a will, obviously she becomes a natural guardian. She can make a will in her own right. Now 9.5 is very important. Section 9.5 speaks about the powers of the testamentary guardian appointed by either the father or the mother, as the case may be. The earlier law in Hariman Prasad, as a decision which you are, I am sure, familiar with, of the Privy Council, the law was that in the case of a guardian for a minor who's acting on his behalf, as long as he is acting for the benefit of the minor, he could even sell the property. Now, natural guardian is subject to the restriction under section 8 against sale, etc., except on obtaining sanction. So you might ask the question whether a testamentary guardian is subject to the very same restrictions, because the law doesn't say so. And the law didn't say so under the 1890 Act. So that is why section 28 of the Guardian Watcher Act, you may kindly read for academic interest. Section 28 actually provided that subject to the restrictions which are cast in a will, the father could actually sell the substance of it. Now, he wanted to get rid of the restrictions and subject to which he would exercise the right to sell the property. He had to approach the court. Now, you must realize that the law under the Guardianship Act contemplates two separate things. One is to appoint a person as a guardian. The other is to declare somebody as a guardian. Now, where does the court declare somebody as a guardian? For example, in the case of a testamentary guardian, he is a guardian because of the will, but he needs a recognition from the court that he is a guardian. So he gets a declaration. When you are not anything at all and you want to become a guardian for the first time, you get an order appointing you as a guardian. That subtle distinction may also be borne in mind. So 9.5 therefore goes on to say that a testamentary guardian is also subject to the restrictions which are contained in the Guardianship Act, which therefore brings in the regime under section 8.2. Like a natural guardian, in short, a testamentary guardian must also obtain permission from the court if he wants to sell the property of the minor, subject to the exception that it does not apply to the his interest in the joint family, which he can sell without getting permission as a karta under the Hindu law. This is a subtle distinction, and now I come to the actual decision which was taken. As I said, the question was whether section 6 which says the father will be the natural guardian and after him the mother, the provision came to be attacked on the ground that it falls foul of the equality guarantee under Article 14 and 15 of the Constitution. Also, a reliance was placed on international covenants, as you know, the Covenant Against Discrimination Against Women, 1979. India was a signatory to it. So the contention was there is nothing in the domestic law which militated against applying the provisions of the covenant to the situation at hand and to declare that a woman, the mother, can also exercise, along with the father, the rights as a natural guardian, because she is otherwise a natural guardian. The only thing is the right is postponed till the death by the literal meaning of the words after. So the court accepted it. This is one of those cases where the court discarded what is called the literal interpretation. These are areas where you could say the court is making the law. The much, critical sort of approach of the court's role, that court doesn't lay around separation of powers. The court is only expected to interpret the law and not lay down law. It's a myth now. Courts do make law from time to time. In various ways, the court contributes to body of law. This is one such example. The court said no. After means 3 or 4 things. The father is absent in a symbolic way. Now, the father is physically there. He may be indifferent. Because the whole idea of a guardian is that there should be somebody to look after his interests during his minority, because the minor cannot take care of his interests. Say, person with regard to his property, he cannot take care. So the court said that if the father is indifferent, he doesn't care, he says, I am not bothered. You do whatever you want. So there is nobody, there is a vacuum. There, the mother can come forth and say, please, I am the natural guardian. There could be cases where the father may himself agree with the mother, you act as a guardian. That also will fall under the interpretation of the word after, which is absent. The whole idea is theoretically that you are there but you are absent. You are not doing anything. So you disable yourself and then you can't create a void. So there again, the father is unable, another instance is where unable because of any physical ailment, mental ailment. In all these cases, literally the mother can step in and along with the father, even if the father is alive, the words after means absent. This is one of those beautiful judgments which must be looked at with greater admiration and acknowledged for the contribution it has made, both in the case of gender equality as also from the standpoint of the welfare of the minor itself. Because who is the mother? The mother who brings up, gives birth, brings up, contributes everything. And then because of our old notions about women not being able to take care of either herself or her own children, these notions have been brought only after. So it has been discarded for good way back about 23 years ago. The next case, if I may, is slightly from a different perspective, which is the Natural Resources Judgment 2012 10 SCC page 1. The next judgment is the judgment which is actually a sequel to what is called the 2G judgment. All of you know the 2G judgment. The 2G judgment is one of those judgments which perhaps is coming for some criticism also because of the theory that in a matter of economic policy, financial management, the courts have made an excessive foray, invasion into the domain of the executive, result of which it is said that it is completely unscrambled the economic policy, causing crores, thousands of crores of loss to the economy, to the person, and interest, economic interest, everything. So the President of India, in exercise of his powers under Article 143(1) of the Constitution. I hope you have with you the paragraph of the Constitution.
Yes.
Now, let us read it together. 143(1), as you know, is an advisory jurisdiction to begin with. It says, power of the President to consult. You must look at the words consult. So it is why it is called advisory jurisdiction. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise, so it is not arisen, it is, even if it is sufficient, it is likely to arise, which is of such a nature of such public importance that it is expedient to obtain an opinion of the Supreme Court, he may refer to the question to that court for consideration. And the next few words are very important. And the court may, after hearing, such hearing as things fit, report to the President its opinion. In all of it, you find that the golden thread runs through. Make it an opinion of the court. President means, of course, the Council of Ministers. President, as you know, cannot act on its own, does not act on its own, except in 2 or 3 situations which are well known. Otherwise, we have borrowed the Westminster system of government, which means wherever the word President is a titular head, like the Queen in England or the King in England, and he acts always on the aid and advice of the Council of Ministers. So here also we have to take it that it's a Council of Ministers aid that. So Article 2, the President may, notwithstanding anything that proviso to Article 131, refer a dispute mention of the said proviso to the Supreme Court for its opinion, and the Supreme Court shall, after hearing, report to the President. Now, why I refer to these provisions to begin with was, there is a marked distinction between the words of wording in section Article 141 and 3.1 and 343.2. The word may is found in 143.1, whereas the word shall is used in 143.2. Now, this distinction is not without purpose, and its purpose has been declared in the judgment which we are dealing with, 2012 10 SCC page 1. The court has gone on to hold that when a reference is made under 143.1, it is open to the Supreme Court to render its opinion, which means it may, as the words declare, it may declare, it may give its opinion. It is not necessary, it is not mandatory for the Supreme Court. There has been one occasion only, I think, in the history of the court, that is in the Ismail Faruqi case, 1994, where the court said it doesn't serve any constitutional purpose and therefore it refused to give the opinion, though the President asked for it. In all the other cases, there were a lot of preliminary objections, but they were always overruled, and the Supreme Court has always given the opinion. There are some of the few things which will have to be done as preliminaries. There are a lot of preliminary objections raised, in fact, when the presidential reference was made. The first preliminary objection was This is a proceeding in disguise to get a review of the 2G judgment. Incidentally, the 2G judgment review was sought and it was dismissed. So how could the president, which means the government, get rid of the 2G judgment by getting a reference meet? Now, what did the 2G judgment say, incidentally? 2G judgment went on to declare that when you actually seek to dispose of scarce natural resources, valuable natural resources of the country, which in that case was spectrum, as you know, government is duty bound to auction the right, and government is not open to government to dispose of these natural resources, because otherwise it will be the first come first. In fact, what was done was first come first basis. So whoever comes first, you get it. So that knocks out the equality clause. It is arbitrary. So auction, the only method, that is 2G, substance of it. So the reference was made on the basis that it may not be always feasible, it may not be always fair for the court to declare that auction is the only method by which a government can dispose of its natural resources. The court was asked to look at Article 39B. Please read Article 39B. It speaks about the distribution of economic, making it available to all. Supposing there is a social purpose, a welfare idea behind the disposal of the natural resources, and it is not the maximization of revenue which is animating the government of the day to dispose of the natural resources. Is it profit alone? If it is profit alone, and if there is no purpose, welfare purpose or social purpose under Article 39B which is sought to be achieved, then the court went on to hold, yes, then if you don't do auction, you will have to account for your action. It may fall foul of Article 14, it may fall foul of all the constitutional guarantees. The next question which the court has proceeded to lay down is, what is a constitutional principle? The contention was that the duty to conduct an auction in the case of natural resources is a constitutional principle. A constitutional principle is, it exists on a very high plane. Say for example, the constitutional principle of equality flows from Article 14 itself, which is the very soul of our constitution. If you see Coelho's case, 2009, it has been raised to almost the level of a basic structure of itself. Because as you know, the constitutional history teaches us that in Golaknath, the 9 judges bench said, fundamental rights, you cannot touch them because it is law. Constitution itself is law under Article 13, and therefore, if you violate the law, you will be falling foul of the Constitution. That is overruled in the 13 judges case, Keshavanda Bharati. There the court said, every fundamental right by itself is not part of the basic structure. When you come to Coelho in 2009, again the larger bench said there are fundamental rights which by themselves can constitute the basic structure. For example, Article 14 by itself, it is at the very bedrock of the Constitution that equality, all are treated equally, the equal protection of the laws. So therefore the argument before the court in the reference was that duty to hold auction in respect of natural resources is a constitutional principle. The court said no. Auction is not a constitutional principle. If it is a constitutional principle, in every case it has to be followed. But then, as the court went on to unfold the principle, namely, that if you view it in the perspective of Article 39B, as also the fact that in the mechanics of it, namely when you actually hold the auction, it may not necessarily fetch the maximum revenue. There are other methods available. And please let the government have a lot more free play in its joints, flexibility. The government which runs the show, and unless and until it is a naked case where there is no social purpose to be achieved, no welfare idea to be followed, and government is only wanting to get the maximum revenue, in which case auction becomes the imperative. Auction is the method. The court had to wade through various preliminary objections. They include that this is a review in disguise. The court said no. When the court is answering a reference under Article 143(1), it is completely different from the review jurisdiction, which is a part of the adjudicatory process between parties. It's a deciding a list. And the grounds on which a review can be undertaken is limited. Whereas 143, if there are questions as which are contemplated in Article 143(1), the court goes on to give his answer. Now, there is a very interesting aspect. You may all ask whether the opinion given under Article 143(1) is law under Article 141.
No.
No?
No.
Why?
It doesn't decide any list. It doesn't decide any list.
It doesn't decide anything. But then, you see, everything is virtually to the court, Supreme Court, sitting in very large number of judges. For example, the Special Court Act in 1978, 7 judges, all very, they apply their minds. Does anyone have any?
Judiciary not advisory.
It is advisory.
Just to opinion.
So is it binding on the Supreme Court as part of precedent? Is it binding on the lower courts? I mean, lower courts means high courts and other courts.
No, persuasive value.
Yeah?
It is a persuasive value.
Sorry?
Persuasive value.
It is high persuasive value because it comes from the Supreme Court. So this very question, you may kindly look up. 1974 1 SCC 717, just for your academic purpose, I will follow it up. That is in the St. Saviour's case, that was decided by 7 judges, 5 judges. Paragraphs 51 and 109. This is Judge Mohan Reddy in paragraph 51 and Justice Khanna in paragraph 109. They have said pretty much what you all said, that it is not binding as such. It is not law. The Vail or the complaint of Chief Justice Judge, you find the echo of it in 1979 1 SCC 380, which was again a special reference, the court's paragraph 101. So there, the Chief Justice Judge in the later decision, 79 1 SCC 380, makes his complaint in paragraph 101. I wish you all go through it, saying that everything is there, the trapping of the code, everything is there. What is the meaning in not giving it binding force? But he finally ends up by saying, noting the criticism of Sirwai, that it remains a purely advisory opinion that's not binding under Article 141. But it has the greatest weight. Now, another aspect of this judgment is the court held that it could overrule earlier judgments of the Supreme Court, which it did. So even in a 143(1) reference, it could, if it is not binding, the logic defies me, it can still overrule earlier judgments of lesser strength, of course. The court also went on to deal with the doctrine of public trust, which you know, is that when you have the government, which is the legal owner of all the natural resources, including air, water, and whatnot, it's still a trustee on behalf of the people of India or the people of a particular country. It's borrowed from foreign jurisdiction. So the doctrine of public trust was also pressed into service, but the court nonetheless held that auction is not a constitutional principle, and if it does resort to other methods of disposal in the context of Article 390, 39B, there's nothing wrong with it. The court also dealt with the history of Article 14. And the court said, originally, as you all know, what was the test under Article 14? Can anyone tell me?
Reasonableness, and now they have developed arbitrariness.
So arbitrariness was developed in which case?
Since 1980.
78. Manika Gandhi. So Justice Bhagwati, who laid bare a new dimension to Article 14 and said it is not confined to only the theory that there should be reasonable classification if you want to get around Article 14, but the law should not be per se arbitrary. Throw back to Anwar Ali of Justice Vivian Bose, a beautiful judgment which I would commend you to read. 1954 by Anwar Ali. Even there, you had the court said that it's very arbitrary and few straightforward, but that has been taken off. Now the question which was dealt with, which is more important, is this is Jain who wrote D.K. Jain who wrote the judgment on behalf of the majority in the reference. He goes on to trace the history and say it's arbitrary, but he goes on to say that a law cannot be struck down on the ground that it is arbitrary. A law cannot be struck down on the ground that it is arbitrary. A legislative exercise, in other words, cannot be interfered with by the court in judicial review of legislation on the ground that it is arbitrary. Now, what are the grounds on which a law can be struck down? Can anyone tell me?
Manifest arbitrariness.
Which are the other grounds?
Legislative competence.
Legislative competence?
Violation of fundamental rights.
Violation of fundamental rights. So, violation of fundamental rights, chapter 3, and legislative competence.
Basic structure.
Basic structure. This is another Rao's judgment you are having in mind. Yes. And supposing it falls foul of any other constitutional principle, constitution law, for example, say 300 and Article 303, which deals with freedom of trade. So, a law, as you know, in Article 13, there is a positive law. A law which is made by the legislature, which includes rules, subordinate legislation, etc., should always be in tune with the Constitution. A principle traced back to Marbury versus Madison, the famous judgment by Chief Justice Marshall of the US Supreme Court, who established for the first time, even without a provision like Article 13 in the Constitution, in the American Constitution, said by way of interpretation that the law made, the positive law made by the legislature or by a subordinate legislation must also always be in harmony with the Constitution, because the Constitution is the Grund norm. The Grund norm, as you know in the Kelson's theory, is the foundation on which all laws are tested. If you remove the foundation, everything will fall to the ground. So the foundation will stand strong by itself, and everything must be in harmony with it, which is the importance of the Constitution we have. Now, though this court, you will notice the 5 judges bench in the reference went on to say that a law cannot be attacked on the ground that it is arbitrary. Is that the law today?
No.
Why?
It has developed.
How? In which case?
Manifest arbitrariness.
Manifest
arbitrariness is a ground.
2017.
2017.
Talak.
Just for your sake, I have noted it. 2019, 17, 9 SCC, page 1. Again, 2 more. Joseph Shine, 2019, 3 SCC, page 39. And 2021, 5 SCC, page 1. Correct? Now, so that law is, so when you read these judgments, it must be a continual, exercise or pursuit of knowledge by members of the legal profession, and nobody should thrust it down your throat. You must develop the interest on your own to continue to read these matters. The court also went on to say that there are limits to judicial review in matters of executive policy making, particularly in the economic field. So the judgment is important from that perspective, that it is clarified the law which was laid down in the 2G case. Auction, yes, if the aim is only maximization of profit, but no, not inexorable, not a principle across the spectrum in all situations, particularly when you have a goal under the Constitution to achieve, in which case you can resort to other methods. It's the substance of what this court laid out. The third case is Shanti Construction versus State of Assam. 2020, volume 2 SEC, page 677. In fact, this is a judgment rendered in review of the judgment reported in 2019, volume 19 SEC, page 529. A suit was filed for money. The suit was found barred by limitation. The contention of the plaintiff was it was saved by section 19 of the Limitation Act. Can you tell me what 19 is? Section 19 of the Limitation Act is?
Extension of time by way of
Extension of time by part payment.
By part payment.
By payment by-
That's part
Payment by whom?
by the who owes the money.
By the debtor.
Yeah.
By the debtor.
Within the period of limitation.
Within the period of limitation. You got it almost, I mean, it's there. So, if section, what is section 80?
It is acknowledgement orally but not acknowledgement in writing and orally but not the part.
Not the part payment. So, what is section 20?
20.
Ah.
It's
It speaks about the persons who are authorized as agents. You see, section 18, 19 and 20 is a kind of a triangle. So, what does it do actually? What is the period of limitation? Where do you get the period of limitation for a suit? You get it in the schedule. We are dealing with the 1963 Limitation Act. And the earlier act was 1908. Section 19 actually corresponds pari materia with section 20 of the 1908 Act. Correct? Now, the question which fell for consideration and which came to be decided in the judgment was about the effect of there being no pleading partly. Why? You take Order 7, Rule 6. When you draft a plaint, if supposing somebody comes to you to draft a plaint, I'll tell you it is one of the most difficult parts. Because what the trial court lawyer does or does not do can be the foundation for either the success of his client or the tragedy of his client. It is a, I mean, you should be thankful to whatever there is, that we are not prosecuted for negligence. In many cases, it's in the legal profession, as you must realize, that it is, what is the profession of, whether it's a doctor, a lawyer. When I go to, for example, dentist, which I did last week, now I look forward to a certain amount of skill. On the table, it brings to bear, the highest amount of skill. I avoid pain, I get out of it at the earliest. I want relief. It's like my going to hospital. No different. Just look at yourself. Now you go to the hospital, you want to get out of it at the earliest. You don't want to spend time there. The same thing in the respect of a person who goes to a lawyer. He comes for relief. We are detaining him. Maybe, there are other considerations, but at the end of the day, our skill, it's a profession, and the important thing is that it is a learned profession. It is a noble profession. End of the day, your life is finite, A to B, you live and die and you go. But what you leave behind during that short period, it's a test for each one of you. That how you, end up actually, end of the day, what have you left behind? What is your achievement? Isn't it measured in terms of the money, the bank balance, the car you travel in? I would say no. It is the internal satisfaction that you get, that you have actually lived by certain principles, that you have been a member of the profession, faithfully adhering to all its principles. So therefore, I will come back to, because there is an issue relating medical negligence where I will dwell upon it. Now, when you come to this Limitation Act, Section 19 has the lady, what's your name?
Anisha.
Yeah, you've done a good job there. So, Section 19, do you have the Limitation Act with you? Because if you have it, because when you take the case, you should have the cases, otherwise, you will not follow. Because each word is important in a statute. Every word should be read carefully 2, 3, 4 times. Then it will sink in. So the limitation section 18, as the lady said, deals with acknowledgement of liability. Now section 18 is general. Why I say general is section 19 speaks about acknowledgement of debt or legacy. Acknowledgement of debt or legacy. Now the word debt is defined as not including a debt under a decree. Now what does it mean? Supposing you get a decree and then you get an acknowledgement later. Will it apply? It will not. Because debt is defined as excluded. I mean, a decree debt is excluded. So debts other than decree debts are covered under section 19 to begin with. Second thing is, if within the period of limitation, there is part payment, if the full payment is made, nothing remains. If part payment, then a new period of limitation will begin from when? From the date of payment. So what is that new period? It is a period which is prescribed under the Limitation Act. So you get a fresh period. It will start from that period. This is one. Now, is that sufficient to satisfy the requirement of section 19 that there is part payment? By that you will get acknowledged. Is section 19 will it apply? Is there something more which is stipulated under section 19? Can anyone tell me? Huh? No, within the period of limitation.
Fresh cause of action would arise.
No, that is there any other requirement apart from part payment to be made
By the same
By
person.
the creditor.
by the same person, by the
That
person who
debtor
is by
is
the,
extending himself that period.
huh?
Debtor.
No, by the payment is made by the debtor or his agent. Either the debtor can make the payment or the agent as defined in section 20. You go to section 20 for that purpose.
There's been acknowledgement in writing.
Knowledge.
It should be acknowledged. This is very, very important. How it should be acknowledged?
In writing.
In writing.
Yes.
Is it acknowledged in writing or is it necessary that sufficient if it is signed?
Signed. Signed. Signed.
It should be signed. It should be in handwriting or should be both. What does section 19 say? In writing or signed. In writing, acknowledgement in writing or signed by the debtor, then it will create a new period of limitation from the date of payment. Correct. Now earlier, the very first year of our republic, this question, section 50, section 20 of the 1908 Act, corresponding to section 19 of the 1963 Act, came for consideration in the decision, which I would commend you to read the whole of it. 1950 AR 51 Supreme Court, page 477. It expounds the true scope of section 19 as it is today. It is the same replication of. The question which, in that case, what happened was, you'll all be really startled to know about it. Sue for money, return statement, payment admitted. Payment admitted by the defendant. Yes, I made part payment. The acknowledgement was sought to be found in the written statement of the defendant. Now, what did the court hold? Not sufficient. Why? Because the cause of action must be complete as on the date of the filing of the suit. Written statement is filed only after the suit. Now, section 19 requires that there must be part payment within the period of limitation by the debtor or his duly recognized agent within the meaning of section 20 as defined in section 20. It must also be accompanied by an acknowledgement in writing or signed by the debtor or his agent. That acknowledgement must be prior to the suit. So the acknowledgement which is sought to be actually relied upon by the plaintiff in that case was found in the written statement. That is after the suit. So cause of action must exist as on the date of the suit, isn't it? So another question which was decided is very important, which is that it is not necessary that the acknowledgement should be simultaneous to the payment. The acknowledgement can be after the payment. Very important. Bear that in mind always. It can be along with the payment. You can suppose you give me a check and I am signing it. It's sufficient. I am giving it. If it is me, if it is proved that I am the debtor or the agent. The acknowledgement can be made in writing by the debtor or his agent after the period of limitation. So what is required to extend the period of limitation is the part payment. If the part payment, in other words, is made within the period of limitation, there must be acknowledgement in writing but the acknowledgement in writing can be after the period of limitation. So interesting it becomes. When you decode it, and as decoded by our court, we don't have to, go there actually. So the court went on to, this court in the review judgment, went on to hold that, see, Order 7 Rule 6, always remember, dealing with pleading. In Order 7 Rule 6, as you know, it speaks about the need for a plaintiff, if his suit is prima facie, it is beyond time, to explain with reference to which law the suit is within time. So a suit is within time when there is an acknowledgement. You must plead it. The need for pleading was stressed by this court. And I just wanted to bring to you the scheme of section 18, 19 and 20. I think that should do the trick. I mean, I can go on, but then I see the time limited and Bhavana is just waiting. And then you have the fourth case is 2009, volume 9 SEC, page 22. This related to medical negligence. It's a sequel to the earlier judgment. I'm sorry, the earlier judgment is 2009 SEC page 221. The successor is 2014 1 SEC 384, which is one of the cases which you have to learn. A couple, Indian couple, who had become US citizens, I think. They hail from Bengal. The wife was a psychologist, husband was a doctor doing research. They came to Calcutta. The wife had a skin rash. Now she went to a doctor. The doctor prescribed some antibiotics. The matter became worse. And in short, she was diagnosed with a condition called TEN. It's 10. It is the epithelial, the necrolysis. It means that the skin will peel off. The infection will set in. You lose your body fluids, and it's a very tragic death. It has to be very carefully attended. You think it's a small thing, just a skin rash. You could die. Particularly if you are actually, given a lot of antibiotics, particularly again in the wrong dose, you give a very high dose. So when you go for skin disease, be careful whether you won't come back home. So the doctors came to be sued by the husband. There's also a criminal case. The question as to the negligence came to be settled in the earlier round, which is the one which is 2009, volume 9 SEC. Page 221. The matter was remanded back for the purpose of determining compensation. And the compensation was granted by the court in a sum of close to 2 crores against the doctors in the hospital. The claimant and the doctors appealed to the Supreme Court, SLP, and it is this batch which came to be decided by judgment written by this V. Gopala. Now the court went on to apply the Bolam test, as you know. Now, what is a Bolam test? Will anyone tell me what is a Bolam test? Bolam came to be decided in the year 1957 in England. It lays down the principle for determining the liability of a medical practitioner in case of medical negligence. Now, what is negligence? And what is the result of negligence? Negligence has its reflection in the law of tort, as you know. Tort deals with damages. Contract, you can get damages under section 73. Tort, negligence. A small reflection of it is 166 of the Motor Vehicles Act. It's based on 163A, no fault liability. You don't have to prove negligence. But in respect of an action based on tort, you have to prove negligence. But when it comes to medical negligence, it is a special field and they are in dire need of protection to a certain extent. So there is a throwback and reference to 2005 volume 6 SEC page 1, which I would commend you to read, by Justice R.C. Lahoti, as the Lordship said was. Jacob Matthew versus Punjab. So that case arose under section 304A of the Indian Penal Code. Indian Penal Code, as you know, 304A, rash and negligent, we call it, usually we associate with motor accidents case. But anyone who is grossly negligent in whatever he does can incur, criminal liability. So he was charged, the doctor was charged with criminal liability. In fact, that was a case where really what happened was a very, fairly old man. He developed, a heart condition, and there was lack of oxygen cylinders. So actually the hospital which was liable, but the doctor was charged, and that with criminal liability. So he came to court. The court laid down, as you know, a very detailed procedure as to how you should proceed against doctors when it comes to medical negligence. A committee that they will look into it, prima facie, and then alone you can charge a doctor. Otherwise you will find, particularly we have a very distressing trend in our country, which is not found in other countries, where wherever somebody dies or something happens, you will break down the hospital, you will physically thrash the doctors. You don't really perhaps know that it's not in their hands. They would have done their best. Now, if they have done their best, you lose life. You lose life in so many ways. You can't help it. But no point in resorting to violence. So, the court in Jacob Matthews' case laid down the law with reference to Bolam. Now, Bolam, what is it? Duty of care. Basically, a tort is a breach of a duty. Every case of a tort involves a breach of a duty. What is the primary duty of a doctor? When a patient comes to you, you can say, I will not take up this case. For good reasons. Not that I will not look at it because if you don't pay me the money. Once he undertakes to take care of the child, what is the next duty? To decide upon the line of treatment. The third duty is, in the matter of discharge of your duties of administering that treatment, you must bring the level of care. So select the patient, the patient is taken under your care, find out what treatment you must give, and when you give that treatment, how you go about giving that treatment. These are the primary 3 duties from which various other duties will arise. The important thing, however, is that the court went on to lay down that as long as the doctor brings to bear a reasonable care, which is expected of a doctor of his standing, not the highest, not the lowest, not extraordinary, not something which you would have done out thinking out of the box, with the benefit of hindsight, you could have done that. I didn't do it. It happens to lawyers also. Just an aside, if you have read Before the Memory Fades by Nariman, F.S. Nariman, in one passage he said something which brings a lot of peace to all of us. He said that I go to court prepared, I deliver my arguments. The court asks me a question and then I rise to the occasion, think on my feet, I give an answer. So I'm very happy. Then I come back in the middle of the night, I get up in cold sweat. He said, my God, how did I miss this one? Which means somebody of Nariman's standing who's got so much of experience, having done his very best, acted bona fide, still you can miss out on something which could have saved your client's case. So what is the extent of our care as professionals? Because people are coming and giving their lives to you, very lives, your property, life, the criminal case, their life itself in your hands. What is the extent of the responsibility? Because with the responsibility comes the excitement that you can serve your fellow brothers and sisters in a profession which is like none else, I can tell you with my little experience. That is the greatest profession in the world, to be a lawyer. And you should go about with the greatest pride that this life you have been given a chance to serve people in all walks of life, safeguarding their rights and the very life itself. So, when it comes to medical negligence, as I have said, these duties have been tested with reference to the Bolam test. No absolute, no, fantastically high standards to be achieved by the doctor, reasonable standards and Bolam test. And how is it usually done? In the case of medical negligence, you will bring a team of experts, as you see. The hospital will bring a team of experts, or the doctor will bring a team of experts. What do they come and depose before the court? This is the general line of treatment. What a doctor should not do, or should do, is that he should not give a treatment or a line of treatment which nobody else would do. Something which is completely unthinkable, which will take it to the field of gross negligence. And it is that level of negligence which alone is actionable, be it under 304A, be it under an action in tort. So the Bolam test was reiterated in this case. Now the important thing is about this case is that the court went on to increase the claim, the amount awarded by the Calcutta High Court by taking note of inflation. When you're coming back to the medical claim, the court said that the case was pending for 15 years. So there's an additional claim. The court said without amendment, this is Goda went on to say that without amendment, you are put on notice, order to rule 2 was taken because in the earlier round you didn't take it, some of the new grounds. No, they're all technical. What is important is to get the proper just compensation. Because actually it is being used both in the motor vehicles case and in the medical claim cases. Basically, there is a subtle distinction that I don't want to go into. The next important thing is about the liability of the hospital. Now this is very important. When you lay a claim, as you will be, against doctors, you will ordinarily search and find out, you will make the treating doctor the party. Now, is there a duty or is it going to be fatal if you do not make the treating doctor a party? The court said no. If a claimant does not make the treating doctor a party, it is not fatal because it is the duty of the defendant hospital. Because the defendant doctor hospital is engaging the doctor, maybe on contract, maybe a permanent employee, maybe whatever method of recruitment. He is treating. They know everything about the facts. The treating doctor must in fact be examined by the hospital. And the important thing is that the hospital is vicariously liable. So the fact that the treating doctor is not made a party, because there is an obligation on the part of the hospital to examine the treating doctor in the discharge of its duty to lay before the court the facts which are exclusively within the province, within the knowledge of the hospital. The claimant may not know. Claimant has to only lay forth foundational facts. He went there, got admitted, he was treated, died or suffered injury, whatever it is. Prima facie, if it makes out a case of negligence, then the burden is on the doctors to tell the court, no, we have done everything. And the treating doctor must be examined. So this is just for your purpose, I would like to refer you to 2020 volume 6 SCC 501. That is the Maharaja Agra Singh Hospital case. Judgment which was rendered recently, where the court has in fact taken notice of the fact that after Bolam's case and after Jacob Matthew, this Supreme Court has departed even from the Bolam test, because the Bolam test was loaded in favor of the doctors. As soon as the doctors were able to produce before the court a team of experts, as it were, who would come and say, yes, this line of treatment which was adopted by the defendant doctor was perfectly in sync. The court will say, no, nothing more we can do, because they have followed the Bolam test. Now the courts have started discarding the Bolam test even. The New Zealand court, the UK Supreme Court, and this court in this judgment, 2026 SCC 501, I would recommend you to read. You will get a full picture of the latest state of the law in regard to medical negligence. So that leaves me, I think, with the last case, which is 2020 volume 5 SCC, page 481. Now this arose under the Right to Information Act. The Chief Information Commissioner directed the CPIO of the Supreme Court to give the file notings correspondence between the constitutional authorities in the matter of consultation and appointment of judges. The next case was, a direction was given likewise by the full bench of Delhi High Court, affirmed by the full bench of Delhi High Court, that the assets held by the judges, information relating to be revealed. Third appeal which was concerned in that case was, in the Madras High Court, there was an accusation that a certain minister, through an advocate, made an attempt at unduly influencing a sitting judge. The applicant wanted details regarding the same. These three appeals came up and finally it got referred to a constitution bench. So this judgment, 2020, Volume 5 SCC 481, is a judgment relating to the right to information and the repercussions on judiciary. Well, as you know, the Right to Information Act is a revolutionary law. So why is it revolutionary? We have the Freedom of Information Act in the United States. In fact, the Law Commission recommended sometime in 1980 that we also need to have a Right to Information Act. The importance of the Right to Information Act is that while we are a democracy, we profess to be a democracy, democracy will be written on water and will be meaningless unless people are equipped with information and knowledge. Now, equipped with information and knowledge about what? Equipped with knowledge about what is happening in the power, in the corridors of power, in the three wings of the state, executive, the legislature, the judiciary, in all public offices. Why does it become important? Because there is nothing like the sunlight of information, transparency, acting as a disinfectant against all kinds of wrongdoings which take place under the cover, under the shroud of night, of secrecy. It is under the cover of secrecy, under the veil of secrecy. You know that all things that go wrong. In fact, I will go on to say that how even though we have 70 years past, the adoption of the Constitution, more than 72 years, 73 years. Where do we stand as a nation in terms of probity in public life? And just an aside, I'm just speaking out my mind, that each one of us have an experience. You go to any public office, in one office where we come out unscathed by, the complete lack of dignity with which we are treated in a public office. Because they think that they are rulers, they can rule over us. In fact, Sarvepalli Radhakrishnan, in a speech in the Constituent Assembly, he said, at least now we can stop blaming the British. They have left us. Now the destiny is in our hands. We cannot continue to blame the British. Today, it's 73 years afterwards. Where are we today? Practically on the ground, what is the level, what is the kind of democracy that we have? At the bedrock of democracy, at the basis of democracy is the people must learn to turn completely honest in our dealings with each other, in whichever walk of life it is. As I said in the beginning, that it is not the kind of money, the bank balance that matters. It is what you have done with your life. It's a search voyage within yourselves. And you find out at the end of the day what kind of a man, what kind of a life you have led, each one of us. If you don't do that, no point blaming governments. No point blaming. We are the government. We are making it. So, Freedom of Information Act was therefore framed by the Parliament. And it's a revolutionary giant step. Now, what was 3 points which were considered was basically the independence of judiciary, right to privacy, which, as you know, by the time the judgment was rendered, because of the Constitution bench which was rendered in the privacy matter, the right to privacy has been elevated to the level of a fundamental right, as you all know. The various facets of which have been unraveled, though not perhaps an absolute right across the board, but still it becomes a fundamental right, it's recognized. So the argument of the Supreme Court before itself was that the independence of the judiciary would be affected if information regarding its various aspects and functioning would be revealed to the general public. It included information related to the assets and other information, relating more importantly to the meetings of the collegium, how the candidature of a particular candidate is considered by the constitutional authorities. If you don't maintain, for example, supposing we get information that an advocate who's being considered is a complete drunkard. Complete drunkard, he is always, and he's in a habit. In fact, perhaps I think there was a case where the intelligence report was that a man is a drunkard. And unfortunately, he would just go along with the others who would drink. So much so for intelligence reports. So, but you have to be careful with the company you keep. That's all that matters. Even, if you have to be careful about what you do, how you move. So, the court went on to dilate upon section 11 and decode it. I would recommend only you to read paragraphs 34 and 35, Justice Sanjeev Khanna's majority judgment that was opined by Justice Ramana and Justice Chandrachud as they were at that time. The court went on to lay down what is fiduciary. What is a fiduciary relationship? Now, if you just have a look at it, I will not deal with it, if you just see the Right to Information Act, it's a weapon in the hands of the citizen provided it is properly used for a bona fide purpose. It can also be the source of, complete harassment of the individual and the destruction of an institution itself if it is misused. Section 11, it has been discussed in paragraph 34, actually gives section 8, I'm so sorry, it deals with the exemption from disclosure. The right is to get the information. The information must be available. Because you can't give information which is not available with the public office. So the important thing is that information is available, and that information, unless it comes in under any of the categories in section 8, it will be dealt with. And I would also ask you to read paragraph 52. So that is where, if you have to wade through the entire judgment, I would recommend, because I don't have time for all this, paragraph 52, it deals with because the information, for example, relating to the assets, it's personal information. Now, the importance of it being personal information is that section 8J says information which relates to personal information, this is exempt. The disclosure which has no relation with the public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless it is satisfied that larger public interest justify the disclosure. Now you will see one important thing is that various exemptions from disclosure are given in section 8.1. But 8.2 is very important, because 8.2 says, notwithstanding the fact that under 8.1, the information mentioned in section 8.1 is exempt from being disclosed, if larger public interest requires the disclosure of the information, then it is always open. This is Sanjeev Khanna goes to say in paragraph 35, it is not a legal right, but it enables the disclosure of the information. Which means this, that today, if it is properly utilized, we have in place all the legislative mechanisms in place, laws in place, under which a citizen, because Article 19(1)(a) gives the right of freedom of expression. Now this freedom of expression for a citizen, it has been laid down, cannot be exercised unless you have information. So what is the point in my expressing my view, my convictions, if I don't know what I should say about people in public office? Therefore, it has been written to Article 19(1)(a), the freedom of right to information. And this is what in substance it was finally laid down. Thank you for giving me a patient hearing and wish you all the very, very best. That's all I can say.